We're opposed to this bill as it's currently written. I talk with Mr. Pittman at least 2 times a year and encourage our people to provide them the kind of information that they want. To the best of my knowledge, they have provided that. If you look at this, Mr. Chairman, I can't see that it's going to help one customer in North Carolina have broadband service. And I thought that's what this committee was about.
It is what the committee's about.
We have a system of disparate treatment. We have broadband service providers who provide some information. We have telephone companies and telephone cooperatives who must provide more information, and yet the charge, I believe, when the NCT North Carolina Authority was originally created, it was to be technology neutral. And I don't think when you create a disparate amount of record keeping for one industry over the other, that that's technologically neutral. It just simply is not.
Could you be more specific, Mr. Allen, as to where the difference is?
Well, you look at number B, it says a telephone company or telephone cooperative subject to the reporting requirement shall include in its annual report the following additional information. I assume that means they got to provide 1, 2, and 3, that stuff that other people don't have to provide. And that's probably unlawful to begin with. It's certainly unfair at the very least. In C, it says a telecommunications service provider, which has a specific definition in our law, seeking an initial or revised state cable franchise map. We just went through revenue laws about what we were going to do to amend the video franchise laws about this very subject in terms of filing reports and the mapping and whatnot, and they decided it was much too early to do anything about that. But yet we are imposing a requirement on a telecommunications service provider that provides that report that's not imposed on some other entity who may not meet the definition of a telecommunications service provider, and that is a specific defined entity under the law. So
what would another entity be that would provide
a cable telephone company? It may not be a telecommunications service provider. A cable television company. It's not a telecommunications service provider under the law. Proprietary.
I'm sorry, let me make sure I understand this. You said a cable television company is not a telecommunications service provider.
That's correct. Do you agree with that?
Yeah, it might be.
Might be or might not be.
If we're providing telecommunications services and we go through that, we might be, but if we're just providing pure video, we wouldn't be. That's not.
Right. So if you're providing high-speed internet access services, you would be.
That's an information service.
That's information services, not telecommunications service.
Okay.
So they would not be.
All right. All right.
So there's a legal problem there. Proprietary information, this bothers me too. It says proprietary information is considered a trade secret under the Trade Secret Protections Act. That's wonderful. But what is proprietary information? If you poll these companies here, there would be a different definition of what was proprietary. I could have 10 pieces of information when a single one of them agree on what's proprietary and what's not proprietary. And where that's a problem, when you start talking about, I want your information by household, by address, I guess is what this means, which incidentally, we may have addresses for people we serve, probably not addresses for people we don't serve. So I don't even know if we have that information based on what my company is telling me. But who decides it's proprietary? I don't believe the North Carolina Authority is authorized to act as a judicial tribunal to decide that. When we provide proprietary information to the Utilities Commission, they can make a finding of fact as to whether or not it's proprietary or whether it's not based on the arguments of the party. But I can see us going to Superior Court time and time again, argue about what's proprietary and what's not proprietary. And Mr. Chairman, that could be in my view. I'm not saying that we ought not to have a good database. I've always supported the North Carolina.
Let me stop you there, and let me ask staff. I'm assuming from the way this is drawn, although I may be making the assumption incorrectly, that which is a trade secret is defined under the Trade Secrets Protection Act.
Yes, and this provision was taken out of the general statutes under different sections. So that's why the language reads as it is.
I know how the language reads, but
well, I understand that. But let me ask you this. I mean, you're advocating to us that there's a problem here. So let me ask you the question, and it somewhat puts you on the spot, but the question is intended to, but not unfair. That's fine. Not
unfairly is all right.
Well, that's fine. I'm going to try to make it fairly.
You'd be the first person, not the General Assembly, but some of my colleagues here.
Assuming that the Trade Secrets Act defines a trade secret, does that solve your problem?
No. I think you still have the same problem because the language is, it's very, very broad. I mean,
you've read the Trade Secrets Act.
Yes. We deal with it all the time.
Okay.
And that's one of the problems. What's proprietary and what's a trade secret? It honestly is in the eye of the beholder.
But we have a system for dealing with that, right? And we have Superior Court judges and
or utilities commissioners or somebody who has a judicial or quasi-judicial authority to deal with those kinds of things has to make those.
But we have somebody, I haven't read the act. You're way ahead of me. But we have in place someone who makes that determination, right?
We do, but I don't know that we provide trade secret information to anybody who is not a judicial tribunal who can make those decisions, and it's just sitting out here somewhere like, I'm not saying.
Well, you provided the public, I mean, you're not adverse to providing this kind of information to a public body charged with the responsibility of trying to provide or oversee or make sure or assist in providing a public service that appears to be critical to our future economy.
I will say a qualified yes to that, but the interesting part of it, when we talk in the next part of it, we say we will only release or publish this in the aggregate amounts that do not identify or allow identification of numbers or subscribers or revenue. So we're going to provide all of this detailed, site-specific, by the address information, but we're not going to be able to publish it anywhere. So I wonder who it's going to help.
Well, I may have an answer.
I don't know.
Well, I may have an answer for you there. Yeah. Well, first of all, just in reading it, I don't think anywhere in here it requires numbers of subscribers or revenues. Now, I understand that's what wouldn't be disclosed, but if you read above, I'm not sure there's any place those two things are required.
Well, I think back here somewhere it talks about providing instead of broadband coverage for households, businesses, and institutions on each street within the company's
exactly. But it doesn't ask for a customer or revenue. And those are the two items discussed on the last page.
Well, I would think if you're providing coverage for households, that's probably customer information.
Well, let me draw.
If it's not, I think this needs to have a little bit more work on it. Let's say exactly what it does mean.
Well, it may need more work, but let me draw for you the distinction and see if this helps any.
Okay.
The information that's being sought are the number of households passed, not the number of households who are your subscribers. Nobody wants your subscriber information, but your households passed, because that's availability. If it's not available, it's not available. If it's available, it's available. And the problem existing now is you cannot, from anything being reported, tell where it is available and where it's not. And the essence of this body being able to assist the public, and to some degree working out public-private partnerships with the providers, is to know where it is and where it isn't. If we don't know that, I don't know how we begin to be of assistance.
Well, Mr. Chairman, I disagree with you to a point. If we know where the central offices are, we know by VHF coordinates where the DSLAMs are, so we know within a radius where the coverage is. I'm not even sure, in talking in the meeting we have today, that these companies even have the addresses for homes not served in their database. I mean, they have the homes that they do serve and who their customers are, but I don't know that there'd be any reason for them to have that downloaded in their.
It's easy enough.
Television companies clearly do not.
It's easy enough to figure out the starting point and the ending point of your line and to do it by an address. And I can't imagine either that they don't have it or couldn't easily obtain it.
Well,
and if they don't, they ought to have it.
Well, I don't know that there'd be any reason for them to have that kind of data, and it just imposes a cost on the system with due respect, and it doesn't provide broadband to another senior customer in North Carolina.
Well, it may or may not. I don't know that I would agree with you on the last one because it depends on understanding